Good afternoon and welcome to the latest residential conveyancing forum for England and Wales. I'm Robert Kelly from Stewart Title, and as always we're joined by Ian Quayle from IQ Legal Training. It's not, I was going to say morning, but it's afternoon now. Ian, are you okay?
It is, Robert, it is, yes.
Yep.
But after a bank holiday weekend, it feels like Friday afternoon, doesn't it? I don't know about you, but mad dash this morning doing loads of stuff. So, yeah, but
Well, that's
thanks
it.
very
I
much
think
for inviting me along.
talking to some lawyers this morning, and bank holidays, whilst they're nice, just shorten the working week.
Yeah.
And the demands are the same every time,
Condense everything in,
unfortunately.
don't we? Yeah.
So not always a great holiday, really. But welcome you all to today's forum. We have some topics which Ian will be talking about, amongst them the recent Law Society suggestions on climate change. And with that in mind, we also have coming up in June a webinar led by Ian and Martello, talking about climate change, what you should be talking to your client about, what you need to explain to them. We'll send details of that out to people shortly. And we also have, starting in June, that other new old idea that's come back, common hold. Only people of the vintage of Ian and I remember it from 2002. True. But for all you youngsters, it is very exciting. And it is actually an incredible way of holding property, and I think will be very successful. So we're running a series of free webinars on how common hold properties can be set up, what you need to do, the effect on conveyancing transactions, and most importantly, how you explain them to your clients. Once again, we'll be sending details of those out to you in the next few days. But now, Ian, if you're ready, let's turn over to this month's topics.
I will. Thank you, Robert. And a massive thank you to Stewart Title and Robert for inviting me along today and for organising these events. Again, just those of you that aren't aware, Stewart Title do an awful lot of support for the legal profession in allowing me opportunities to speak to you. Robert was saying we've got some webinars forthcoming. We've also got a number of conferences, and Robert isn't aware of this, but our Manchester conference is just about sold out now. So that's in July. It is free. I'm going to talk about being sold out. That's not the right term to use. It is free. If anyone wants to come along, there are a number of places left, but not many. I'm expecting it to be sold out by the end of the week, but it'd be great. We're also organising lots of conferences and events all over the country. And again, you're more than welcome to come along to those. Robert and his team will be in attendance, and it's nice to see you in person. The other thing is that Stewart Title sponsor Property Law UK, and the May edition is due out tomorrow. I'm just sort of finishing the editor's letter, which will be accompanying the presentation, the publication rather, but that's quite interesting and worth a look at. Lots of interesting cases and articles, one on the new sort of terrorism legislation that's important for commercial landowners and commercial property owners, written by Andrew Butler Casey, and all sorts of other articles. I think there's about 4 articles this month, one on adverse possession that I wrote, another couple rather on residential leasehold transactions and service charge issues, and one on climate change that Robert just touched on a little earlier. Again, as far as Robert's concerned and his colleagues, his contact details are on file there. As far as Stewart Title is concerned, they do have a variety of bespoke policies and an online presence which you are able to utilise. Do speak to Robert and his colleagues, because they can provide in-house training that I think is compulsory, if I'm right, Robert, if you're still with us, relating to compliance. And I know that Robert is quite happy to come out to firms to talk to you about that training. Sorry, Robert, I think you'd switched off there, but you're back on.
I'm back on.
That's
no,
right,
yes,
isn't it? You do training on compliance.
We can provide in-house training. It is a requirement of the SRA and the CLC that you have training on the regulations relating to the sale of insurance, and have that on a regular basis as well. So we're happy to come out. We can't promise to make it interesting, but we can promise to make it relevant to the sort of work you and your firm do. And the other thing to bear in mind is that this now falls under the ambit of the FCA, who are always keen to find a few scapegoats. So it may well be that these rules, which have been bubbling away in the background for a while, are now more important. So very happy, get in touch and we'll come and do some training for you.
Yeah. Don't listen to Robert. It's not boring. I've heard it, and it's really useful, and it's something you've got to do. So, and as I say, again, a really kind invitation for Stewart Title to organise that. If you are using Stewart Title currently, fantastic. If you're not, do talk to Robert. One, he's able to, in some cases, issue bespoke policies that perhaps other insurance providers aren't. And in addition to that, the sort of standalone policies and online policies are very competitively priced from premium perspective. So it's always worth having a chat with Robert, Freddie, Ted, and the team to see what they can offer you. Anyway, as Robert was saying, topics for today. A number of topics. I always mention useful websites listed on there. Interestingly, property protocols and the boundary dispute protocol, do have a look at that, because I was reading the Sunday Times on Sunday, surprisingly, a lot of articles about boundary problems and boundary issues and why they're sort of prevalent at the moment. Property protocols, boundary dispute protocol, free to access and brilliant in connection with giving you information about how to deal with boundary issues. It's probably useful for clients as well, to be honest with you, that article in the Sunday Times, but probably protocols, the go-to site for boundary issues for resi conveyancers. The rest of those things I've mentioned to you before, so we'll skip over that. And topics: Law Society guidance on climate change aimed at residential conveyancers. I've opened up the chat. Has anyone read it? The good news is, I think for once, the Law Society is sort of backed off providing you with a whole list of things that you've got to do, and actually has provided guidance that I think is helpful. Where I worry is where it's sort of intimated that it might be prudent for residential conveyancers to be trained on climate change and to provide detailed advice. It doesn't say outright you've got to do it, but it sort of suggests it, in my view, and I think that's dangerous. I think just as in all other aspects of residential conveyancing, other than issues relating to title, our task is simply to indicate to client the existence of risk and to say to clients where they can go in order to determine the extent of that risk. Zara saying waste of time, we have a building safety crisis. Come on to that in a moment, Zara. But again, as far as the guidance is concerned, there's nothing startlingly new in it, in that it relates to three types of risk: physical risk to property, transition risk, regulation legislation created by government that requires property owners to incur cost or perhaps impact on marketability or value of residential property. It contains a sort of checklist and some suggested wording for the report on title and scoping the retainer. My view is that you do as you've always done and say to the client that you can obtain a climate change report and you recommend it, but then explain to the client that you won't be giving any detailed advice on the content of the report, and merely indicating to the client the types of risk, sort of common risk, that could be encountered with regard to climate change as a consequence of residential property ownership. As Zara says, the Building Safety Act continues to create problems and issues, and there's a few things really that I want to mention to you. Firstly, we've still got this problem with regard to government guidance concerning the Building Safety Act. And we've got the first tier tribunal in two cases basically criticising the government guidance and saying, you know, at the end of the day, it is just guidance and doesn't have any sort of lawful or legal authority. And you've got the guidance itself saying, comply with the guidance and ignore what the first tier tribunal is saying. I don't know when we're ever going to see a situation where that issue is resolved until we have either upper tribunal or better Court of Appeal decisions explaining which prevails. And as far as I'm aware, there's nothing in the pipeline that's going to mean we're going to have that answer or the answer to that question anytime soon. So we've got this sort of impasse at the moment where we've got government guidance and the government guidance saying follow this, and we've got first tier tribunals, whilst not saying don't follow it, in connection with particular issues saying the guidance isn't correct, or we as a tribunal aren't prepared to follow it. So that's an important point just to bear in mind. The other important point to bear in mind is something that I've been working on recently, and that is this. There was a school of thought, there is a school of thought, that Part 2 of Schedule 8 of the Building Safety Act applies to any lease. And just recently I've been doing some work on this, and the conclusion is that it doesn't just apply to any lease, it applies to certain leases, but those leases must predate the 14th of April 2022, sorry, 14th of February 2022. So the advice that I'm now giving firms, and the recommendation I'm making to you when you're giving advice to clients, is that the Building Safety Act Schedule 8 Part 2 applies to any lease in a relevant building, provided the lease was granted before the 14th of February 2022. That shouldn't be sort of earth-shattering news for you if you're dealing with residential conveyancing, but may be an issue with regard to any of you that are doing mixed use work, because you may have commercial tenants that would be protected by paragraph 2 of Schedule 8 if the commercial lease predates the 14th of February 2022. But it would seem that such a lease is not protected if it was granted after the 14th of February 2022. Why I say it doesn't matter to residential leaseholders is because a residential lease, if it post dates the 14th of February 2022, is not protected in any event. The next thing that I want to talk about with regard to the Building Safety Act is case law. There are a number of cases that have been heard in the Court of Appeal. We're still waiting for judgment in connection with those cases, but they won't really help us with regard to the issue concerning leaseholder certificates and landlord certificates. Alison, is an extension of an older lease as per the later amendments to the Act. That's right, Alison. Yes, such a lease would be excluded, save a continuation lease as defined by the regulations in connection with residential long leases. So yeah, going back to the BSA, we haven't seen a case, other than the case of Lena, that gives a residential conveyancer a steer as to how to deal with leaseholder deeds of certificate and landlord certificates. The next thing to talk about with regard to the Building Safety Act is the fact that we do need to be careful where we're advising clients, residential leasehold clients, that the Building Safety Act doesn't apply currently. I repeat the point that where we have airspace development, a building that currently isn't a higher risk building could become one because of airspace development, or the government could amend the Building Safety Act and regulations so that higher risk buildings are buildings that are higher risk for the purposes of the BSA, but aren't buildings that exceed 18 metres or 7 stories in height. And to that end, I refer you to the Grenfell Inquiry report and the recommendation that higher risk buildings defined purely and simply by height or number of stories is arbitrary and inadequate. Yeah, Alison, yeah, you're right about that point, 100%. Okay, but do watch out, because the continuation lease is defined in the regulations, isn't it? So you could encounter a situation where you have a residential long lease extension that isn't a continuation lease as defined by the regulations. So great point, Alison. Thank you for that. Alison, by the way, are you doing much BSA related work? And again, I'll just ask the room today. We've got 60 people attending. Anyone in the past that wasn't doing BSA related work that's now saying we're taking it on? So by that I mean firms that prior to this year weren't doing it and now doing it. So anyone willing to share what you're currently doing with regard to the BSA? Insurers are saying, you know, they don't see why we shouldn't be doing it. But some firms are still rather reluctant. But on my travels, I'm saying there are still some firms that aren't touching it, but there are others that are saying, well, we've really got to. So Alison's saying we only tend to do leasehold, so I've always done. But yeah, okay, I think you've got to. Davina, still not dealing with leasehold flats in relevant buildings or high risk buildings. Davina, are you warning clients, however, that although the BSA doesn't apply to the flats or apartments that your clients are purchasing, it could apply in the future if there's airspace development or if the definition of a higher risk building changes? Jane, hi Jane, we're not dealing with any leasehold purchases at all, just sales. Okay, and that's BSA related sales, Jane. I think obviously that's the safest transaction to get involved with. Yeah, only do advise about airspace development. To be honest, it doesn't matter if a building becomes a relevant building. The thing that worries me is if it becomes a higher risk building. If it becomes a higher risk building, there's two important points. Firstly, as I've mentioned before, the service charge is likely, excuse me, to rocket because the duties and obligation on the landlord increase dramatically, and the landlord can transmit the cost incurred into service charge as a result. That's the first point. And the second point, which is important, is that there are now terms implied into residential long leases if a building is a higher risk building. Right, Zara found one on the share where the original development gone bust, but being handed an AWS1 and lender is asking me to confirm the borrower will not have any additional liability. Point zero there, Zara, is how can you confirm that? I mean, that's the thing. Lenders shouldn't be asking you to confirm that sort of question because you can't, can you, Zara? Unless you're prepared to take the risk. Yeah, okay. Joe, in the position of transfer where the flat is affected, probably owned jointly, but one person can offer one person. Should all three sign a leaseholder deed of certificate? The point there, Joe, is only one person has to, doesn't it? One owner has to sign the leaseholder deed of certificate. So it's a really interesting question, that, isn't it? What I would say there, Joe, is if this is a new leaseholder deed of certificate in the context of what you're saying, the person signing it should be the person that is able to sign it on the basis that the lease is a qualifying lease. So if you've any doubt, just be careful about that and check. But if a property is owned jointly at the moment, either of the co-owners or any of the co-owners can sign a leaseholder deed of certificate, and that would be a valid leaseholder deed of certificate going forward, Joe. Remember, a leaseholder deed of certificate is an important, I describe it as a golden ticket for subsequent leaseholders. So if the current leaseholder is signing a leaseholder deed of certificate or executing a leaseholder deed of certificate on the basis that the lease is a qualifying lease, then that means the lease is a qualifying lease for any future owner. Has anyone had any issues with the point Joe makes? I think I'm right on that. There's no obligation on all leaseholders to sign a leaseholder deed of certificate. It can be executed by one, and it could be executed by any leaseholder who is able to state that the lease is a qualifying lease. Because I have had firms ask me, well, if X signs it, the lease is non-qualifying because they would own, or they, as of the 14th of February, own this flat and they owned 4 others. But we have another co-owner who is occupying this flat as of the 14th of February, and it was their home, and no one, owns their home. Well, in that case, they sign the leaseholder deed of certificate. Hi, Hayley. We are seeing a number of beer issued in connection with, it's a lender who owns multiple, so none of the leases are qualifying leases. Yeah, that's a big problem, isn't it, Hayley? I don't think they've thought about Islamic finance in the context of BSA at all. Actually, it's something I should do some work on. Let's make a note of it. I'm going to look at that. Yeah. So, right. And I mean, the problem is that, as I mentioned earlier, Hayley, the fact is that if the lease is non-qualifying, because of the status of the leaseholder as of the 14th of February 2022. That has drastic consequences, doesn't it, for future owners? Interesting question. Has anyone seen any survey or valuation evidence as to the devaluation of a leasehold property if the lease is a non-qualifying lease? So has anyone seen any data to say, well, if this lease was a qualifying lease, that flat or apartment would be worth 280. But because the lease is non-qualifying, it's worth, 210. Anyone ever seen that or had that? Because it is a valuation issue, isn't it, as well as being a legal issue? Yeah, Zara, you haven't regularly can't sell the flats. Yeah, I get that. But I'm just interested about this valuation point. But yeah, so Zara, but has anyone actually said what the percentage of devaluation is? Because my guess is that would be a really complex issue, wouldn't it? Yeah, I get that, Zara. Because, does it become worthless? Does it lose 50% of its value, 20% of its value? Do you have to assess what the potential additional exposure is to service charge as a consequence of being non-qualifying? Yeah, well, I get all I'm looking there, Haley, is on survey. Yes, and Laura, I think it's a good question to ask. Do you? Well, clearly you do. And sorry, you've seen zero value. Wow. Wow. Yeah, that's right. Well, yeah, that's Alison, that's one of the things I always say. It's not blanket protection, is it? It's blanket protection in connection with remediation work for relevant defects. And unless you know what a relevant defect is, you're sort of completely in the dark, aren't you? Someone who's on the verge of having his property repossessed, can't sell, can't remortgage, and will be made bankrupt. Yeah. I tell you what, I had over the weekend, everyone, an interesting one. A guy who's buying a property and 30% of the purchase price is cryptocurrency, right? And he was just about to exchange contracts, and his conveyancers backed off right at the last minute and said, I can't act. So this guy was begging me to tell him, were there any firms that would do work where the buyer was buying with cryptocurrency? I'm doing a webinar on cryptocurrency shortly. And my view is, to be honest, that looking at cryptocurrency as a source of funds for a purchase, I don't think you can safely act. But I knew that there was one firm in London that will act for a buyer who's buying with cryptocurrency. But this guy was sort of just about in tears, really, saying, what can I do? I'm due to exchange. I'm going to lose this property. Can you help me find someone who can act if I'm buying with crypto? And my view was, well, I don't think I can help you here, but there is a firm that I know in the past has done this sort of work. You could contact them, whether he's been successful or not. But my guess is, and again, we've got lots of people attending today, anyone here willing to act on for a purchaser who's buying with cryptocurrency? The fact it was 30% of purchase price, I thought, well, even if you would act, that's a lot of a percentage of purchase price being used, isn't it? So I would be very reluctant indeed to act. But can anyone answer that? So, or am I getting from the silence a fact that you'd all say that's a definite no, thanks, Ian, we wouldn't act? Anyone? And well, yeah, so it is really tricky, to be honest. I mean, what you've got to do, first of all, is you've got to say, how did you buy your cryptocurrency? And then you've got to look at the cryptocurrency itself. So you've got a number of levels of potential fraud. You've got someone that's obtained funds via criminal activity that puts it into cryptocurrency. Okay, so you've got that issue. You've then got the cryptocurrency itself being a vehicle for fraud. And there's an issue with regard to, well, yeah, Mark, but again, the problem there is you're going to say, well, where do you get the cash from? I mean, if you look at the AML stuff, and again, it's not a topic for today, perhaps we can talk about it next time, but you look at it now, and you're looking at sources of funds and sources of wealth, and you're being told by all professional bodies to sort of chase the cash down. Oh, that's interesting, Karen. I've heard of that again, but a firm that did that, the forensic accountant wasn't able to conclude exactly where it came from, and therefore, they were back to square one again. Thanks for that, Zara. Yeah, they are. Yeah. There's no doubt about it. Someone was telling me the amount of costs involved in AML, particularly where you've got third-party sort of funding from friends and family, it's sort of suffocating the marketplace. Yeah, or it's making the conveyancing prices sort of rocket because of the additional work that you've got to do. Anyway, we might perhaps talk about that next time rather. On my list, lessons from recent case law and residential leasehold service charges. A few things here. One, there's been a case recently where the court was prepared to imply a term into a residential long lease that enabled a landlord to recover legal costs in connection with litigation. that was relevant to the landlord and leaseholders. You've also seen some cases recently where the tribunal rather, was prepared to imply a term into a residential long lease that enabled a landlord to vary how service charge was apportioned. And I've seen other cases where the courts have looked at sweeping up clauses and said, we don't like them, they're not enforceable. What you must do is list the sorts of expense that are being considered by the original parties to the lease, but then say the list is not exhaustive and other items of a similar nature are recoverable, this sort of thing. So there's loads of stuff. Yeah, I'm going to, Zara, are those decisions going to filter over to management companies on freehold estates? I don't know is the answer, because I mean, obviously you can distinguish between leasehold and freehold, can't you? Interesting to see just what the tribunal has done. Has anyone had any issues with regard to estate rent charges recently? Just sort of changing tax slightly and exploring the point Zara made. Anyone sort of seeing a challenge being made on estate rent charges, and are we all exercising caution with regard to what we say to clients about estate rent charges? The reason I mentioned it was talking to someone over the weekend that was saying someone had bought a freehold house, hadn't been advised that there was an estate rent charge, and was being met with a rent charge demand for the current year of £1,000. And was basically saying, well, you know, I wasn't aware of this, and was saying that in the report on title, the issue hadn't been touched on, which is extraordinary, but I would say it was unusual, to be honest with you. I'm sure most firms are going to tell clients, look, there's a potential liability here for the estate rent charge, and, you know, not the same opportunity to challenge estate rent charge as there is with regard to challenging service charge. Someone was telling me over the weekend as well, the Leasehold and Freehold Reform Act doesn't really help estate rent charge payers, does it? It helps people with regard to traditional old-fashioned rent charges, but not estate rent charges, is their view. And I think last time I looked at the Act, that was my view as well. So yeah, there's lots of case law on residential leasehold service charge. There's a few of them that I'm referring to in Property Law UK. Right, Zara, we need to be careful looking at these freehold estate service charges. Sometimes there's no mechanism to deal with insolvency. Yeah, these charges can escalate, and a lot of these are putting through fake charges. Well, yeah, fair comment. I mean, again, you need to look at how the estate rent charge is referred to in the documentation, Zara. There should be some form of dispute resolution mechanism. There should be some form of obligation that the estate rent charge must be a reasonable amount in connection with expenses that are reasonably incurred. We need to look at all of that. So although we've got, you know, in a lot of cases, the removal of the enforcement provisions under Section 121 of the Law Property Act 1925, there's still a lot of opportunity with regard to estate rent charges for an unscrupulous freehold owner to see it as a profit-making mechanism. Anyone else got any comments on that? The other thing I saw recently with regard to residential leasehold service charge was legal costs being incurred, and the tribunal saying, well, they're administration charges, and again, subject to the test of reasonableness as a consequence. Remember, I think it's the Landlord and Tenant Act 1985 deals with the opportunity to challenge service charge on the issue of reasonableness. You're also entitled to challenge administration charges on the basis of reasonableness. I see that a lot, where landlords are charging exorbitant fees for retrospective consent for alterations. The cost that the landlord charges in that context is an administration charge, and therefore capable of being challenged. The other point to note, really, just going on from Zara, is watch out with regard to what would have been a leasehold house. because these days, you shouldn't be selling, or developers shouldn't be selling leasehold houses. And watch out with regard to leasehold flats where there is a nil ground rent, because what some developers are doing is putting in a standing management fee. So instead of charging a ground rent, the developer is saying, as far as service charge is concerned, there's a standing service charge fee per annum of, say, £500. And all they've done is converted what would have been a ground rent into a standing management fee. Again, I would warn a client about that. Zara says, are you able to use Landlord and Tenant Act 85 to challenge valuations for non-statutory lease extensions, share it where clients are being charged full premiums instead of according to a percentage owned? I don't think, well, you can challenge the valuation if it's a valuation fee, but not what the valuation is, as that's not an administration charge, Zara. Okay, next thing I want to talk about is common hold. And again, I'm mentioning lots of people at the moment. I'm being asked to do training on common hold, which is why I'm delighted to say that Stewart Title is sponsoring a series of, as an introduction to common hold. We've now had a little bit more clarity about what the government is thinking with regard to reform of common hold. So again, that is an issue I'll be exploring in the series. For those of you that are thinking about detailed in-house training on common hold, it's something you need to be aware of, but I don't think it's something that's terrifying that means you need urgent training on it. I think I would sit back and wait, see what the government does with regard to draft legislation, which is due out autumn or winter this year, and then have a look at training. But I think it's important that you are aware of how it looks currently, because I think the sort of fundamentals of common hold are sort of set in stone. So the training that Stewart Title is supporting me to deliver is looking at that. And I think you do need that awareness, and your fee earners need to be aware of it, and also need to be aware of the type of documentation that you're likely to encounter when you are seeing common hold activated, as it were, which I think is going to be 2027, and I think it will be activated on the basis of new builds to start with. Anyone had any issues ever with regard to common hold? Right, going to have, well, yeah, Zara, you're spot on, right? Common hold will not get over the Building Safety Act issues and problems. All that will happen is that the Common Hold Association replaces the landlord, and the Common Hold Association, which is made up of the unit holders, used to be leaseholders, it will be met with remediation costs, and it won't be able to transmit those costs into the what's called the Common Hold Assessment. At the end of the day, my gut reaction is that with a common hold scheme, the unit holders, the owners of flats and apartments within the building, are going to be left picking up the tab. The only thing I could say with regard to common hold is the government might say to landlords, if we're going to give you grants or give you funding for remediation work, a condition will be that you volunteer your building to common hold. So I could see that happening. But you're right, Zara, the fundamental issues are still going to be the same. Whether it's a freehold, whether it's a leasehold scheme or a common hold scheme, if I'm going to complain about the costs that are incurred in connection with the management of the building, I'm going to gripe and complain about those things, whether it's a common hold scheme or a leasehold scheme. The only difference being I'll be griping and complaining to a landlord if it's a leasehold scheme, and I'll be griping and complaining to the Common Hold Association if it's a common hold scheme. One of the things also about common hold is I think the government's thinking is that rather than these common holds being self-run, there might be an obligation for a professional manager to be appointed as a director of the Common Hold Association. And again, as far as that's concerned, that alleviates some of the problems with self-run schemes, but will lead to an increase in costs relating to the running of the building. Okay, dealing with land registry restrictions, again, just doing a lot of work on this at the moment, and saying to practitioners, when you're acting for a buyer, audit the title. Are there restrictions on the title? Can I comply with that restriction? And will I be able to comply with it within the timescale prescribed, courtesy of my land registry search and my priority period? If there's the slightest hint that that's not going to be possible, think about disapplication and think about making that application as soon as possible. The other point with regard to land registry restrictions is that there's been some sort of further guidance with regard to the use of double L restrictions to prevent property fraud. And I was just reading recently, again, insurers are saying property fraud is still out there, seller identity fraud is still out there and still an issue. So please, please, please be careful when acting for sellers to make sure that you're doing the appropriate checks and that you're alive to the risk of fraud, even where you've done electronic client verification identity checks at the start of the transaction. Be aware that there may be other issues arising during the life of the transaction that mean that you need to assess risk or talk to your compliance teams. Right, so I've covered that off. Has anyone seen this case of Savage against 60 Kent Road Maintenance Limited? 2021 decision, drawn to my attention by my dear friend David Keatley. I don't know if you know David, he's a great guy, but he was talking to me about this case a while ago, and I was having a look at it just recently. And it's a really useful case because the judge in this case said it's a really well-established principle that where a restriction requires prior approval from a specific individual and that individual is deceased, the restriction is said to automatically lapse. Now, when we talk about restrictions here, folk, I shouldn't really have put this next to land registry restrictions. It's talking about the restriction of a restrictive covenant, okay? So what you've got here is if there is a restrictive covenant in favour of an individual and that individual is no longer with us, has departed this earth, then the position is the restriction is said to automatically lapse. So it's really useful if you're looking at a restrictive covenant in favour of an entity that no longer exists. Now, in that case, you were talking about a deceased landowner. But what about a company that's been removed from company's house? Again, in that situation, it's not physically dead, but legally dead, isn't it? So again, there's an argument that the restrictive doesn't apply. A word of caution, of course, it is possible if the company is a dissolved company for the company to be reinstated. So I don't think Savage is direct authority on for the proposition that where restrictive covenant is in favour of a company, if the company is being dissolved, the restrictive covenant automatically falls away. I don't think the case is authority for that. It's more limited. It is where there is a individual who owns land that has the benefit of the covenant, and the covenant is personal to that individual. Again, I was talking to someone just recently about restrictive covenants. Again, a word of warning, please, please, please do not in a report on title simply list the existence of restrictive covenants, either in the charges register or in a conveyance contained or referred to in the title. A restrictive covenant is not simply enforceable because it's referred to in the charges register of a registered title. You either investigate to confirm it is enforceable or it isn't, and I would suggest that that is an unwise series of investigations to undertake, or better, in my view, to say to the client the title reveals the existence of restrictive covenants, but you haven't checked whether they're enforceable or not, and if they are enforceable, by whom. Only where there is a restrictive covenant that directly impedes your client's objective or intended use of a property would I suggest that additional investigation is required, or in situations where you or the client or a valuer considers that the existence of a restrictive covenant impacts on value. So can I ask, does everyone in the report on title say to the clients, here's a list of restrictive covenants, and do they attach to that a caveat to say we haven't investigated enforceability, or do we just list them? And again, and we've mentioned this before, but I do think it's important, do we say to a client where there are restrictive covenants, it may be possible to buy out the covenant, or it may be possible to make an application under Section 84 of the Law Property Act 1925 to vary or remove it? So again, can I ask, what would you do? Debbie, Amelia, anyone else? Hayley? With restrictive covenants in your report on title, do you list the covenant and say we haven't investigated, or do you just list and say the property is burdened by these covenants, or do you perhaps say the title may be burdened by the covenants we haven't investigated? Please just be careful with your report, because if you're saying the property is burdened by restrictive covenants, and it later transpires that the covenants are in fact unenforceable, and they may be unenforceable on the basis of what we just looked at in the decision of Savage there, we've got it wrong, haven't we? If, on the other hand, we investigate all restrictive covenants to determine enforceability, I think we're leaving ourselves wide open to negligence claims. Because, if we get it wrong, boy, do we get it wrong. Zara, thanks, Zara, for coming back to me on this. Just list them. Problem I'm having is where housing is restating the covenants on transfer dealt to them on a staircase, so there's a huge list of covenants saying the same things. Yeah, but do you list them with a warning, Zara? That I don't know whether they're enforceable or not. That's the issue. Yeah, I think you've got to have that warning. And in a situation where you're investigating for enforceability, do bear in mind, if we may need title indemnity insurance, and investigatory work that we undertake could potentially invalidate a policy. Yeah, I think isn't it sensible, Jane, to do that? Because the number of times a restrictive covenant is on a title and it's not enforceable. So just saying to a client in blanket form, your property is burdened by restrictive covenants, I think is potentially wrong. I think that's a good point as well, Debbie. Will it impact on their use of the property? Yeah. You should always ask about client objective anyway, shouldn't you? And I mean, there's a guy called Christopher Heather Casey at Tanfield Chambers, who's the man to go to really on restrictive covenant issues. And he says one of the major problems with regard to enforceability of restrictive covenant is not identifying the land that has the benefit of the covenant. Zara, could you hazard a guess that new ones were companies around, they could take action, but older ones are not? Yeah, possibly. But, again, the company might still be around, Zara, but the covenant could still be unenforceable. So, I don't want you to think about writing a 14-page essay about enforceability of restrictive covenants. I'm just saying you add to, here's a list of restrictive covenants, a caveat, I haven't investigated whether they're enforceable or not. Yeah, Wendy, fair point. Yeah. Well, that's the other issue, isn't it, Zara? The more you listen to me and the more you include in the report on title, the less impact key messages of the report on title are having. So it's a question of how you get over that. And I don't know if I've told you, one of the things I would love to see, and perhaps AI could, probably AI could do it now, is a situation where instead of having a report on title, right, you're acting for me, I'm buying a property. Using the estate agent's video recording of the property or whatever it may be, okay, there is a virtual walk round, and in that virtual walk round, there are pop-up boxes about boundaries, about restrictive covenants, about shared drives, about whatever it is. And the client has that virtual walk round, sees the pop-ups, has to click a button to say they've read the pop-up and read it, okay? And therefore, on the conclusion of that virtual walk round, all the important issues relating to title have been disclosed to the client, and the client, in confirming that they've read each and every pop-up and understood it, the client is acknowledging their awareness of the issue. And if you did that, and the client then turns around and says, well, I wasn't aware that there was a restrictive covenant, well, you could say to the client, well, there's a virtual walkthrough of the property, and that's what you saw, and you ticked or clicked to say you understood or appreciated that particular point. Now, I'm not saying that replaces the long form report on title that we send to the client, but that would get over this issue that Zara's making, that clients just don't read them. Do you think, I suppose the question is then begged, would a client sit down for 20 minutes or half an hour and and actually go through the virtual recording. Zara, the sort of technicality of it, I don't get, right? The point is, how do we get the key or important messages in a report on title across to the client? And how do we get them to confirm they have read it? Yeah, Alison, what I would always say in your report on title, or the email that you send out to the client along with the report on title, or hard copy letter, I would always say to a client, unless you tell me to the contrary, I will assume that you've read this document. Well, I'd ask the client to confirm receipt. And I'd say to the client, unless you tell me to the contrary, I'll assume that you've read this document and you've understood it. It's your responsibility to tell me if that isn't the case. And then if a client in 2 or 3 years' time said, I didn't read it, or I did read it, but I didn't understand it, I think you've got an argument. But I see negligence claims against conveyancers where the client is saying either I didn't read it or I didn't understand it. And there's some vulnerability there as a consequence. I think that's the things are, getting the client. I mean, there's some firms I know that get the client to sign the foot of every page of a report saying they've read it and understood it. And I mean, it's ridiculous, isn't it? But I think that's what we've got to do. We've also got to think about making our reports on title more client friendly. So I think everyone now avoids legalese. I think that message has been received loud and clear. But perhaps using interim reports, perhaps using third-party resources to explain or support some of the things we're saying is really useful. But given the fact that clients are spending less and less time reading, and I was reading somewhere that someone was saying that you're now getting youngsters, using Robert's terminology a little earlier, that don't know how to use the telephone, because of technology and all that goes with it. So, the fact that we're sending an email to a client and asking them to read it, is that not old-fashioned? Is there not a way, and I go back to my idea, which I haven't patented yet, by the way, of doing something that means a client has a different way of looking at important information? You're right, Alison, it is madness. It's just like, terms and conditions that you see online, how many people actually read them, how many people just tick the box and say, yeah, I've read it. Well, yeah, Zara, that's the logical conclusion, isn't it? And the problem, Laura, is you say, we've got an insurance policy that means if something goes wrong, happy days, the client isn't going to suffer or lose out. But I do think there needs to be a long, hard look at how we transmit information to clients and how we prove that information has been received and digested by clients. And no, as far as insurance, well, yeah, professional indemnity insurance isn't guaranteed to pay out, but a lot of clients will look at that as a sort of their backstop with regard to a problem or a claim. If there's anything wrong with the title or if there's anything wrong with due diligence, we've got a lawyer with a nice professional indemnity insurance policy that we can call upon to recover our loss. Yeah, I've had that, Sue. Yeah, I've had people saying, well, can you just tell me about it? Yeah, I once acted for a client who couldn't read or write. Dead now, I just found out about a month ago, died. But yeah, a very, very successful businessman who couldn't read or write. So what was the point in sending him a report on title? The answer wasn't. What you used to do is to go along with a colleague and I'd go through the report line by line, ask him if he understood and ask him if he had any questions, and a colleague writing down everything that was said, literally everything that was said. I mean, thinking about it, we should have recorded the meetings, but didn't think about it in those days. But we do need to be careful. Anyway, obsolete restrictive covenants, Savage against Kent Road, really useful. Yeah, Zara, I'm not technically minded, but I'm sure the bright young things are able to do something that can record Teams calls and put them on a file somehow. Anyway, talking of Zara, a question from Zara. with regard to transfers of part in shared ownership leases? Zara, you're our go-to person with regard to shared ownership leases. So, standard transfer with sometimes a second estate service charge. I don't see the need for them to repeat. I agree. How important would you still need to include some rights granted or reserved? Anyone have got any comments on what Zara is saying here? And Lara, you're right. Yes, you would need client consent with regard to the recording. So just look at this then. I don't see the need to repeat verbatim what's in the transfer to the housing association. They were just thinking if you have a row of 5 houses that the housing association bought into one title, you still need to include some rights granted or reserved, etc. You do, Zara. What I was thinking about this was a point that we've discussed in the past, which I think is really problematical, where a housing association takes a head lease of units in a block of flats, for example, and then you've got shared ownership leases derived from that head lease, and they need to check that the service charge in the shared ownership leases mirrors the service charge in the head lease. So I think we've talked about that in the past, and you've said that's a problem. But shared, and so just taking standard transfer with sometimes a second estate service charge. Yeah, is there any need for them to repeat verbatim what's in the transfer to the housing association? I don't think there is the need, but I can understand why. They do add on administration fees for passing on service charges. I've seen leases where housing association shared ownership leases actually deal with that specifically, but you're saying sometimes they miss it. Zara, remember, if it's not listed as a service charge cost, it's potentially not recoverable. So that would be my argument on that point, Zara. Right, well, does anyone have any burning issues or burning topics then? So let's just summarize what we've looked at today. We've talked about climate change. And as I say, I'm not as sort of unduly worried about it as previous. I think the Law Society has been pretty sensible for once. Building Safety Act, I think this sort of fight between tribunal and government concerning government guidance is continuing, and with no sign of it being reconciled. Residential leasehold service charge, some interesting articles in Property Law UK. If anyone is interested, let me know. Actually, I'll tell you what we'll do. Anyone that attends today's forum, I'll make sure that you get a copy of the May edition of Property Law UK sent out to you. How about that? I'm feeling very positive and refreshed, having had a bank holiday weekend. So why don't we do that? With this case of Savage against Kent Road maintenance is really interesting. We've talked about common hold. We've talked about land registry restrictions. And as a case, this Savage case is really interesting. So yeah, we'll do that. Send me an email to the email address shown, and I'll make sure that we get the May edition of Property Law UK sent out to you. And if you twist my arm, we might be able to offer you a discount on subsequent subscriptions. You never know your luck. Anyone got any other issues or any questions? Again, thank you so much. I'm conscious it's holiday week. You know, people have got children and issues, and shortened week, as Robert was saying, means we've got all our work condensed into 4 days. So I'm really grateful, Zoe and everyone else, for your time today. Zara, having to pay 405 for management pack and 1,000 for legal fees for a deed of variation. Yeah, management pack administration charge, Zara, would be my question there. Sue, as ever, lovely. Mandy, thanks very much. Anyone here new to this? Anyone, this is the first forum that you've attended? Amelia, no problem at all, and thanks for coming along. Anyone not attended anything like this before, or this type of forum before? If you have, if it's your first time, send me an email as to what you think. Are you, Sarah? Well, has it been useful? And would you like us to look at any topics or any speakers that you'd like to come along for future ones? Great, that's great, Sabrina, and you as well. That's fantastic. Okay, well, hey, it's not scary. Look, I come at this because I see the nightmares, right? So, and my job is to share with you the nightmares that I see, so that if you see anything similar, you know what to do, right? So don't be scared, all right? Well, listen, on that note, I'm going to finish. Leah as well. So lots of first pick. Great. Listen, everyone, if you're new, How many of you use Stewart Title or are aware of Stewart Title? Do have a chat with Robert and the team, because it's really useful. You might have an existing title insurer, but have a chat with, you do, Leah, that's great. Have a chat with Robert and his team, because as I say, they can provide guidance. And it might be that you don't necessarily need a policy, but Robert can give you a steer as to what to do, or he and his underwriting team can provide help. Oh, that's great. So lots of positivity for Stewart Title. That's great. Thanks, Leah. Thanks, Donna. Thanks, Sabrina. Well, I'm going to finish. Sarah Louise, everybody else, thank you so much. Yeah, that's right. Fantastic, Wendy. Great. Good to hear. Thank you so much for coming along today. Thank you for all of you that contribute. Zara, as ever, thank you. You are my go-to expert on shared ownership. Rebecca, everyone else, fantastic. Okay. I'm really positive today because you won't believe this. As a football team supporter, Leeds United are my first team. Sunderland are my second team. And Newcastle United are my third team. So how about a weekend where all went very well? And I suppose really I'm a Huddersfield Town supporter too. So there's something for the record. Victoria, always a pleasure. Joe, as ever. Yeah, Wendy, no, I don't support Southampton. All right. Anyway, listen, folks, thanks very much. Robert, thank you very much. Anything to add, Robert?
No, not at all. I think it was really interesting. Some good topics there, aren't there? And
good feedback about ST.
Well, exactly. Yes, that's good to hear. We're always grateful for anyone else who wants to join us. Please get in touch and discuss what we can do for you. But very keen to support the industry in whatever way we can. Fantastic. Robert, speak soon. Everybody else, thank you so much. Have a lovely day and enjoy the rest of the week. Thanks very much. Cheers. Thank you. Bye-bye.